Good morning, everyone. We are going to give it just a minute or so to allow people to connect before we get started. So just hang tight for about a minute. I see people already pouring in from registering, and we'll get started. All right, everyone, we're going to go ahead and get started. Good morning. My name is Michaela Wishmeyer, and I'll be moderating today. I am the Research and Communications Specialist for Prosperity, Indiana. We are so excited to have everyone here today for Fall Outlook for Hoosier Renters. What is the CDC Eviction Moratorium? Today on the line, we have Chase Holler from the Neighborhood Christian Legal Clinic to share his insights on the recent CDC order. And we will also be hearing from our new coalition builder for Prosperity, Indiana, Natalie James, who has some awesome upcoming information for us. But before I turn the webinar over to our executive director, Jessica, I wanted to mention a few housekeeping items. So currently all lines are muted for the presentation. If you would like to ask a question, you can use the raise your hand function, or feel free to type it into the Q&A box. We will be having a question portion during the webinar. As always, technology can be a bit troublesome at times, so if you lose your internet connection, reconnect using the link that's been emailed to you. And finally, we will have the presentation slides and recording available on our Prosperity Indiana COVID-19 Hub. That's going to be accessible for everyone. So if something happens, you will still have access to the information from today. And now I wish to turn it over to Jessica Love, Prosperity Indiana's Executive Director, for some opening remarks.
Thanks, Michaela. Good morning, everyone. Thank you for joining us for another webinar focused on evictions prevention, and specifically this time around how to ensure utilization of the CDC eviction moratorium to ensure housing stability. It's critical to not just listen in today, but to share what you learn afterwards. One unfortunate thing that we're hearing is that in watching eviction proceedings, many are learning about rental assistance options for the first time in front of a judge. And since a specific process must be followed to take advantage of the CDC moratorium protections, we want to make sure we're helping our partners understand the rights and process outlined by the federal government. Because again, we would hate to see families who are eligible to take advantage of the moratorium be evicted because they didn't understand their rights or the process. Housing instability always affects families and communities. But during a pandemic, it can create a cascade of public health concerns that further impact us all. So thank you for being here, for helping us to stand in the gap, and for being part of the solution. I'm thankful for our team members for pulling together this webinar, and for the partner that Neighborhood Christian Legal Clinic has been in this work. We could not do our work without our partners or without the support of our funders. We're very thankful to have Indianapolis Foundation support our work related to increase rental assistance to improve housing stability for the lowest income residents in our community through coalition building, and informing eviction prevention efforts during this critical time. And we're excited to announce today, with more details to come before the end of the webinar, an eviction-focused series that's being sponsored through our grant from the Indianapolis Foundation. So stay tuned for those details as well. And now, without further ado, I will hand it back over to Michaela to introduce our speaker today. Michaela?
Thank you so much, Jessica. A quick snapshot of Prosperity Indiana and who we are before I introduce Chase. We, for more than 30 years, have been mobilizing our members to create economic opportunities and improve social conditions, particularly for Hoosiers who are most disadvantaged. We are a statewide cross-sector membership network of about 200 organizations and individuals. Our impact through members has strengthened communities and improved lives in rural, suburban, and urban areas in every county. Ultimately, our mission is to build a better future for our communities by providing advocacy, leveraging resources, including providing training and consulting services, and engaging an empowered network of members to do the important work. We have members who represent human services, arts, legal aid, congregations, workforce development, real estate, government, financial institutions, private, nonprofit, really people all over across the state in all sectors. And if you are not a current member and are interested, please visit our website, prosperityindiana.org, to learn more. So today we'd like to welcome Chase Haller, the staff attorney and director of housing and consumer justice for the Neighborhood Christian Legal Clinic. Chase graduated from the University of Dayton School of Law in 2011 after earning a bachelor's degree from Indiana University in Bloomington in 2008. At the Neighborhood Christian Legal Clinic, Mr. Haller focuses his practice on consumer law, including mortgage cases, landlord, tenant, rent-to-buy, and other legal issues affecting low-income Hoosiers. Chase lives with his wife, Megan, and their 2 children in Greenwood, Indiana, where they are members of Mount Pleasant Christian Church. Without further ado, I'm going to hand it over to Chase to begin his presentation.
Thank you very much for that introduction. Work on sharing my screen here. Okay, can somebody let me know if they can see my screen all right?
Everything looks great, Chase. You are good to go.
Thank you. Well, thank you for that kind introduction, and Jessica, likewise, thank you for setting up this issue, this presentation, this conversation today around some of the issues that renters are facing all around the country and in our state, right in our backyard. People who are really struggling to, make their rental payments. Wanted to focus the conversation today on the CDC eviction moratorium because there are a lot of questions about, the scope of it and kind of what's happening on the ground. There's a lot of news stories that have been focusing on some people still getting evicted, and I'll talk about how and why that's happening in some circumstances. Again, my name is Chase. I'm a staff attorney at the Neighborhood Christian Legal Clinic. Give you a little bit of background about the clinic we've been doing. We're a nonprofit legal aid provider. We've been in the Indianapolis and Fort Wayne communities, been in existence for over 25 years. Providing legal services and education to our low-income neighbors as a means of demonstrating Christ's love, and have really appreciated the partnership with Prosperity, particularly the reach that they have around the state and different stakeholders to have these kind of conversations about policy and how it's affecting moderate to low-income people in particular. So without further ado, I want to do a little bit of a backdrop of the national eviction crisis. So a recent study by the National Council of State Housing Agencies estimates that U.S. renters will owe up to $34 billion in past due rent by January 2021. That same report estimates 150,000 eviction filings in Indiana by January 2021, with an estimated rent shortfall between 376 million and 485 million. I want to thank Andrew. I saw this, he posted this report, I think yesterday, and I looked at the report and am sharing some of the statistics that he did on Twitter yesterday. A local study was conducted by the Indianapolis Neighborhood Housing Partnership, who's been a longtime partner of ours at the clinic. They commissioned a study that revealed that close to 30,000 renter households or 22% of all renters in Marion County are at a heightened risk of eviction under the current economic circumstances. That's a pretty shocking figure. It certainly tracks with, the massive amounts of unemployment that we've seen and business closures and people that are affected in particular industries like service industries and being subject to shortened hours and layoffs and all those sorts of things. The one other thing that the report highlighted was the disparity in the effect of this situation. So this same report that INHP conducted shows that households of color are 38.4% more likely than white households to be at heightened risk of experiencing an impact from eviction. 28.5% of all Hispanic households are at risk of experiencing impact due to greater employment in industries that are experiencing those high economic disruptions like I just mentioned. That's again a figure that should concern everyone who cares about equality and how these things are affecting different populations. About the CDC moratorium, a little bit of background. So the moratorium was enacted September 1st, 2020. It became effective September 4th in the Federal Register, and there's a cite to it there. The Centers for Disease Control and Prevention are the ones who issued the order entitled "A Temporary Halt in Residential Evictions to Prevent the Further Spread of COVID-19." So they're hinting at, the overall health purpose of the order. The order was made under the authority of the CDC director under 42 CFR 70.2, which empowers the director to take such measures to prevent the spread of the diseases as he or she deems reasonably necessary. And since it took effect September 4th, it effectively created a nationwide eviction moratorium for qualified tenants until December 31st, 2020. So just want to be clear, it does have a nationwide scope, and including Indiana. It basically sets a floor. So to the extent a state has a more restrictive moratorium, those restrictions also apply. Our state moratorium ended, and therefore this is the only moratorium that is currently in effect in Indiana. So in the order, it also states that, just to that same point, that it is a floor, and in areas where there's already a moratorium on residential evictions that provides the same or greater level of public health protections than those listed in the order, those are still in effect. The next question is logically, what housing is covered? Because there are many different types of housing. There's, mobile homes, there's, rent to own agreements, all these kind of things. The CDC order is pretty broad. It prohibits any landlord, owner of a residential property, or other person with a legal right to pursue eviction or possessory action from evicting a covered person from any residential property in a jurisdiction where the order applies. Landlord and owner are not further defined by the order. Residential property is defined to include any property leased for residential purposes, and goes on to specify that term also includes any house, building, mobile home, or land in a mobile home park or similar dwelling leased for residential purposes. For mobile homes, that's pretty important because often someone will be purchasing a mobile home on contract, but then just renting the lot separately. So this would include that situation as well as one where they're renting both the trailer and the lot itself. So it's pretty broad. It would not include a land contract or a purchase, and it does not include foreclosures either. The definition does not include any hotel, motel, or other guest house rented to a temporary guest or a seasonal tenant. So obviously someone couldn't move into a hotel room and then claim protection under this particular order. The next question that might arise are what stages of eviction are blocked? The order prohibits a landlord from evicting a covered person from a residential property. Evict and eviction means any action by a landlord, owner of a residential property, or other person with a legal right to pursue eviction or a possessory action to remove or cause the removal of a covered person from a residential property. So again, it's a very broad definition. It says any action. So I interpret that to include all phases of the eviction process, including a landlord sending somebody a notice that they have to leave, filing the eviction action itself, or the notice of claim for possession, holding additional hearings, entering judgments for possession, and even enforcing post-judgment possessory orders. And basically what that means is, someone has already gone to court and gotten an eviction order that states a tenant, must leave within 72 hours. If that tenant is eligible and they follow the guidelines in this order, they should be subject to having that the execution of that judgment stayed. And there's a way that they can do that by filing with the court. I'll talk about. In terms of landlord penalties, if a landlord disobeys the order and unlawfully evicts a tenant, they may be fined up to $100,000, spend a year in jail, or both if a tenant is evicted and contracts COVID-19. If a tenant is unlawfully evicted, contracts COVID-19, and dies, a landlord can be fined up to $250,000, face a year in jail, or both. So they're very strict civil penalties in the event that a landlord would violate this order. As we'll see later, I don't see that landlords are approaching this with much caution, I think, with the way that they're filing some of these evictions, but we'll get to that here in just a little bit. Now I want to talk about tenant eligibility. So again, we heard earlier that the protection applies to a covered person. So then the question is, what is a covered person under the CDC order? To be a covered person, there's basically a 5-part test. So there's an income eligibility test, there's an inability to pay full rent test, there's a test around whether the tenant sought government rental assistance, there's a test as to whether the tenant made best efforts to make timely partial payments, there's a test around the health risks that the eviction would cause in terms of the tenant being forced to use emergency housing or have to lodge with friends and family members or something like that in more dense housing. And I'm going to walk through each of these tests individually. So for the first test for income eligibility, a tenant must expect to have income less than $99,000 in 2020 as an individual, or $198,000 as a joint filer, or they must have received a stimulus check under the CARE Act. So that's a really simple one. If somebody's gotten a stimulus check in the mail, they know they'll pass this income eligibility test. Or if their income is such that they didn't even have to report income to the IRS last year for the tax year 2019, they also are eligible under the income test. These are typically people who earn below the minimum required by the IRS to report their income. So these are very low income earners, typically somebody just earning, Social Security retirement or something like that at a very low amount. In terms of the second criteria, the second test is inability to pay full rent. And so a tenant must be unable to pay full rent because of either a loss of substantial household income, loss of compensable hours of work or wages, layoffs, or extraordinary medical bills, which is defined as any unreimbursed medical expense likely to exceed 7.5% of one's adjusted gross income for the year, or oh, I'm sorry, there shouldn't be an or. So it's one of those two things. Either they've lost substantial wages or they've had extraordinary medical bills that exceed that 7.5% threshold. The third test is a tenant must have used best efforts to obtain governmental rent assistance. And I want to make a note here that as of the drafting of this presentation, the Indiana State Rental Assistance Program was closed with all the money allotted to that spent. And the Indianapolis Rental Assistance Program has many thousands of folks still waitlisted for assistance. So I think to qualify for this test in good faith, basically a tenant needs to be able to show that they've at least tried. So put in an application if they're able to show proof that they're on a wait list, or that they just visited the page and that it shows that it's closed. And that's in the event someone would question whether or not this statement was true. But right now, there really aren't any government assistance options because the programs have largely run out of money, which, unfortunately, I heard in the news last night that stimulus talks have stalled yet again in Congress. And so it doesn't look like it's likely that we're going to get a new stimulus package in the near future. And unfortunately, that's, when we're talking about this moratorium, you can't talk about it without also discussing rental assistance and the importance of rental assistance, because the reality is the moratorium just delays the inevitable for many people if they're not able to make up those lost wages, and that's what rental assistance does. It bridges that gap. So definitely some continuing concern over the fact that there's not additional funding for rental assistance. Test number 4, a tenant has to make best efforts to make payments. And the way it's defined in the order is, it says the tenant must make best efforts to make timely partial payments that are as close to the full payment as the individual circumstances may permit, taking into account other non-discretionary expenses. So keeping in mind that, there is an out here in the sense that if someone truly can't afford to pay their rent because of their other non-discretionary expenses, they potentially don't have to pay anything. But I would advise someone, just to be safe, to at least attempt to make partial payments, an amount that's affordable to them. If an eviction's been filed, the tricky part about that is the landlord typically cannot accept partial payments after they've filed an eviction case, or they have to refile their case. So basically, I think the tenant just has to make contact with the landlord, try to make some type of partial payment if they're able to. And obviously, this puts the tenant in a pretty tricky circumstance. This definition is kind of hopelessly ambiguous, and most of these people aren't going to be in a circumstance where they can pay anything. If they're back to work and they're making some money again, it might be a good idea for them to pay up to a third of their income if they can afford to do so. Test number 5, the eviction would cause health risks, basically. So this is that density of housing issue. So they must attest that being evicted would cause them to become homeless, or they would have to move in with a friend or a family member due to a lack of other available housing options. And, what I encounter a lot with tenants in this situation, particularly if the eviction's already been filed against them, that it becomes a really difficult choice for them, because here they're in a property where they're facing an eviction, and if they try and pay the landlord and still are subject to an eviction, now they've lost that money to move. And then also, if there's an eviction filed against them and they're looking for another place to live, there are a large number of housing providers that if you have a recent eviction, they won't even consider you as a tenant. But of course, they'll still take your application fee. And so someone that's low income or living paycheck to paycheck, the idea that you could just throw away $35, $50 to 2 dozen different apartment complexes is just not realistic, knowing that you're going to get turned away. So I think that the hope is that In particular, housing providers would be looking at tenants anew and figuring out how their financial circumstances have changed since the eviction. I've encountered plenty of tenants that, that they're the worst of their financial situation was several months ago, and they're back to work, or their seasonal hours are picking up, or what have you. But that's not true for everyone, but for some people it is. And I think the hope is that housing providers would understand how broad this is affecting people. Again, thinking about the INHP report, the fact that 22% of all renters, one in 5 people, is potentially subject to a heightened risk of eviction. This is something that's affecting everyone pretty much across the board in some way. Now, if a tenant meets those criteria, that's not enough. They still have to take some steps on their own to obtain protection. This is the part that I really want to focus on, because I don't want, as far as an education component of the CDC order, the most important thing that tenants need to know is that it's not enough that they just meet the 5-part test. They actually have to take some action on their own to make sure that they can get the protection. So basically, to be able to get the protection, they have to review and attest that they qualify under all 5 tests. And when I say review and attest, they're signing under penalties of perjury, basically, that they qualify. And the CDC has issued an official form for this. Each adult listed on the lease, rental agreement, or housing contract should complete the declaration. The CDC order does make it clear that in order to be protected, each adult tenant on the lease does have to sign a declaration. So each adult tenant basically should sign and submit the declaration to their landlord, the owner of the property, or the person who has the right to have them evicted or removed. So you might think of this as, the property manager, or in some cases the attorney, if the case is proceeded to court. We've also advised people to file the declaration directly in court in the event there's already an open eviction matter. And the reason being that is proof of notice then to all parties. It'll be distributed to everyone, and you don't have to worry about, the landlord saying, I never received it, or something like that. Tenants should use the official form declaration. There's a link there that I'd be happy to share somehow with y'all, but you can easily do a Google search and just search for the CDC eviction form, and it'll come up. It should be one of the first things that comes up in a search. And it's just a simple 2-page form that lays out all of those qualification criteria we just walked through, and then there's a place for them to sign and date. We're also working on some self-help tools. We have a cover letter on our website. If you go to www.nclegalclinic.org, under our consumer and housing program area, there is a fillable PDF cover letter and then a copy of the declaration form that tenants can fill out and print and then use to submit to their landlord. We are also working on a self-help tool, which would be a standalone website where tenants can go and submit their information and have a letter automatically, or an email automatically generated to their landlord. That tool is in development, and I expect that we'll be able to release more information about it towards the middle of this month. Just a note that, again, they can file in court. Otherwise, a best practice would probably be obtaining a proof of delivery, either having somebody sign for it by certified mail, or literally walking it into the office and have somebody sign, a receipt, something like that, or an email read receipt. Any of that would suffice. The attestation, or the sworn statement that they're signing to, basically just states, I understand that any false or misleading statements or omissions may result in criminal or civil actions for fines, penalties, damages, or imprisonment. And the declarant, or in this case the tenant, must certify the truth and correctness of the contents under penalties for perjury pursuant to federal law. So That is one thing to be careful of. I have no idea how widely enforced, this would be if somebody actually did submit it without it being truthful. But that is, I think tenants need to understand, it's if you don't qualify for protection, you certainly shouldn't sign and submit it to your landlord. Now, there are some exceptions. I want to be clear about that. The CDC moratorium is meant to apply to non-payment evictions, so primarily for non-payment cases. And there are exceptions for different circumstances where a landlord could still pursue an eviction. So the catch-all exception provision says nothing in this order precludes evictions based on a tenant, lessee, or resident engaging in criminal activity while on the premises, threatening the health and safety of other residents, damaging or posing an immediate and significant risk of damage to the property, violating any applicable building code, health ordinance, or similar regulation relating to health and safety, and lastly, violating any other contractual obligation other than the timely payment of rent or similar housing related payment, including late fees, penalties, and interest. So this last catch-all provision is something I'm going to delve into a little bit, because this is where we're seeing some, I guess I would call it some creative methods by landlords to try and get around the CDC protection. I'll talk more about that later. But first, I want to go through a few frequently asked questions. So first, does a tenant have to prove that their financial hardship is related to COVID-19? That's a logical question. Most of the rental assistance programs have had to have a specific connection to COVID-19, and the answer is no. The CDC order does not require that the renter's financial hardship is COVID-19 related. It's very broad. What if the tenant is already subject to an eviction order? So unless the eviction is being conducted under one of the exceptions that I just went through, the order does block all phases of the eviction process. So eligible tenants who are going through an eviction should quickly provide their landlord with a signed declaration and file a motion to stay the execution of the possessory order. I realize that sounds like something that most pro se people representing themselves wouldn't be able to do. Indiana Legal Services and the Neighborhood Christian Legal Clinic can provide these pro se forms to tenants. We pretty openly share forms with one another, particularly if they're ones that can be used by pro se tenants or people who are representing themselves. And I do know we have, in particular, we have a motion to stay execution of the possessory order that was drafted by our friends over at Indiana Legal Services that they shared with us. So we have been sharing that with tenants and times that it's appropriate. Does the moratorium halt payments or late fees? The answer is no. The moratorium simply halts eviction activity. So all other aspects of the contract remain in force. And basically what we're telling tenants is, even if you can't pay your rent, keep your head down. Don't be, making noise or getting into fights with management or other tenants. If you want to be entitled to the protection, you need to make sure you don't violate any other provisions of your contract. So talking about emerging issues, there's one issue in particular that has to do with that bolded provision that I was walking you through all around other contractual violations being an exception to the CDC order. So I'm going to highlight it again here, and it says violating any other contractual obligation other than the timely payment of rent or similar housing related payment, and that includes late fees, penalties, and interest. So this is from an advocate's perspective. Keep in mind, I have a particular perspective from the tenant side because I represent tenants. But in my opinion, landlords are abusing this catch-all provision, and I'll walk through an example of that. So here's one of my clients that I'm working with right now. The initial filing is made in small claims court. I think it was a month and a half ago or thereabouts. And it says, you can see it, hopefully it's not too blurry, it says this tenancy expired because of non-payment of rent. So basically, we're filing this case as a non-payment of rent case, and we're entitled to possession based on that provision that the tenant didn't pay. So the tenant in this circumstance, they actually got a copy of the CDC declaration from Indiana Legal Services, as it would happen, and filed it with the court. And this is just the heading of that filing: the renter's declaration, temporary halt and evictions. They filed it as a motion in the small claims court where this case was filed as a pro se person. And the judge responded and said, okay, this matters before the court. The tenants filed this COVID-19 declaration. Basically, that means they're a covered person, and then this matter stayed until the end of the year, unless there's an alternative basis for an eviction. And so that order was put into place, and the tenant felt that they were protected at that point. Well, then the landlord a few days later amended their notice of claim. Basically, it's a little bit of a bait and switch. Oh, did I say non-payment of rent? I actually meant, oh no, this is a holdover tenancy. I'm not suing them because they didn't pay their rent. I'm suing them because their lease expired. So that's what a holdover tenancy is. So this is a circumstance where, let's say you have a lease agreement that runs from March to March. It's a 1-year lease. March, the whole year comes, you get to March of the next year, the lease expires, you happen to be behind on rent. Well, there's been a moratorium in place ever since then, essentially, either a statewide moratorium or now this federal moratorium. And so the lease is expired and that tenant is still living in the property. They're technically considered what's called a holdover tenant. In some circumstances, the contract may state that it automatically renews for a period of time. So it might, a lot of them say they'll convert to a month-to-month tenancy at a higher rate, and then they're subject to termination by written notice, or it may state that they have to vacate immediately. The contracts aren't all the same in this regard. Most of them have an automatic renewal provision of some kind, and some kind of process for termination by written notice as well. So what's the problem with this interpretation? So just thinking about this logically, the whole purpose of this order, the CDC order, was to provide the broadest protection possible for tenants. So that we don't have a circumstance where we have, hundreds and thousands of people subject to an eviction during a worldwide pandemic, potentially increasing the spread of the disease, particularly now into the fall and winter, when the health experts have told us it's going to potentially be a very difficult time in combination with flu season. But if you think about this logically, over a 6-month period, which is about how long these combined moratoriums have lasted since March, April or so until now, roughly half of all residential lease agreements would naturally expire, right? According to their terms. And so if a tenant was in default when their lease expired, of course their landlord's not going to choose to renew their lease. And of course that's connected to the fact that they didn't pay rent and should be subject to protection, right? And the problem with interpreting it otherwise and saying that, oh no, that's a lease violation and therefore they're subject to eviction, is you'd have, half the people that should be entitled to protection would now be subject to possibly being evicted. And so basically, over the course of the next 60 days is being kind of a crucial period, the only period that people are currently entitled to that protection. If that interpretation holds weight in court, and if judges think that's a valid argument, then we're going to have a lot more people evicted than anticipated, I think, under the CDC order. So landlords basically are using this particular phrase to exact their evictions, violating any other contractual obligation, because it is kind of a broad term, right? So here's some possible counter arguments to that position. I realize that this isn't necessarily a fully attorney audience, and that's fine. I just want you all to be aware of where we're coming from an advocate's perspective. So counter arguments to that position is that any action that does not violate the lease or present a risk to the landlord or their property is protected from eviction under the order. Secondly, a lease non-renewal notice for a delinquent tenant, a tenant who's delinquent on their rent, should raise a presumption that the eviction was filed for non-payment and is therefore prohibited. So in other words, a circumstance where somebody happens to be behind when their lease expires should raise a presumption that the reason for non-renewal was because they were behind on rent, and therefore that is truly the reason for the landlord seeking an eviction, which makes it prohibited for them seeking the eviction. The 5 enumerated grounds, so the 5 exceptions that are listed, do not specifically say that lease expiration or non-renewal is an exception to the order. And lastly, if you look at the terms of the contract, and a holdover tenancy is not specifically a contractual violation, then it should not be covered as an exception. So we have a few clients where we're litigating that issue. We're working with other legal aid organizations to kind of think through strategies to protect tenants subject to these kind of evictions, because it's a really important issue. The CDC order is only effective if it's preventing actual evictions. If people are still being evicted, then it's not working as intended, and that's something as advocates that we need to really focus on and protecting tenants in the current time. And again, this next 60-day period is crucial. Health experts have suggested that the fall and winter are going to be really crucial to keeping the disease at bay. And tenants continue to await crucial aid, and that's the other plug here is, just making sure that you're talking to your lawmakers about the aid that's needed. Both of the rental assistance programs that were both the statewide rental assistance program and the Indianapolis rental assistance program, I believe both of them were closed within a couple of weeks. And I think even I could be wrong on this, but I think even the state one closed within a week with the demand. So it's there's still thousands of renter households throughout the state that are in desperate need for rental assistance. I have been encouraged by how generous some local organizations and churches and other sort of private rental assistance programs have been, and that's great. But it's not enough. I mean, there needs to be a much wider safety net for these folks who were affected by something they could have never predicted, and many of them are just desperate to keep a roof over their head as the seasons turn colder here. I'm hearing those kind of desperate pleas every day on our intake line. So I did want to mention again, we have a frequently asked questions page about the CDC declaration form on our website. We have a fillable declaration currently on our website. When we're able to announce this other self-help tool, I certainly will share that information with Prosperity so they can share that information with their network. I did want to do a plug that Indiana Legal Services also operates a tenant help desk on Thursdays from 10 a.m. to noon, and that's at 317-973-1673. That may be particular to Marion County, but they do have some other regional lines as well. And again, we're working on additional self-help tools, and I'm hopeful will be available soon. We can announce publicly so that tenants can access it. Because the important thing is no one is subject to protection unless they fill it out and submit it to their landlord. And I know one of the things we've had experience with at the clinic is that sometimes when when a person is eligible for assistance, the uptake rate can be really low. And the example I would give is that we have an expungement statute that allows people with criminal records to basically seal or expunge those records so that they can find, you know, better employment and that sort of thing. And there was a study out of the University of Michigan that shows that those kind of expungement statutes have less than a 10% uptake rate. So I guess what I'm saying is, when we have this self-help tool available, I would just call on, you know, everyone that's on this call to share that information in their networks. Our reach on our social media is very small. There are only a certain number of people who really follow us or are interested in what we do. But all of you have, you know, can cause a ripple effect and get that information out there so people can actually get this protection. Because what we're seeing is, even the people that are subject to the protection are still being sought, you know, to be evicted. And so we need as many people as possible to know about this tool and to use it. So again, we'll announce that as soon as we're possibly able to. But that concludes my presentation. I did want to give an opportunity for questions in case anyone had any specific questions that arose out of the presentation today.
Thank you so much, Chase. Very helpful, very informative. So at this time, please feel free to put your questions into the question box. We're going to do our best to get through all of those. And then there is also the option to raise your hand icon. So the first question we have is, if a nonprofit agency or township trustee receives a grant from CDBG entitlement community for rental assistance, and a resident applies for financial assistance, can they use that program as evidence of having applied for government assistance?
I would say absolutely. Township trustees' offices, that's their primary function, really, is assistance to the poor and providing that kind of thing, and they are considered a government agency, I guess. So I would say absolutely yes. I think that would apply.
Our next question, somebody was working with a client and the landlord would not accept partial payments. Do landlords have to take those partial payments if a tenant offers them?
So some of this may depend on what the lease says about partial payments, if anything. But I will say, typically a landlord can insist on receiving a full payment. But you know, it depends on when the payment is made as well, and whether there's late fees assessed and that sort of thing. The only time I've seen landlords really get strict about not accepting partial payments is once the eviction has been filed. And that's because they would potentially have to refile the case if they accepted a payment at that time. So I guess the answer to the question is that it probably depends on the terms of the lease, whether or not the landlord has to accept partial payments.
And I believe this next question you covered, but how does a tenant inform a judge in eviction court about the CDC eviction prevention order?
I think I missed the first part of that. Could you repeat that, please?
Yeah, how does a tenant inform a judge in eviction court about the CDC eviction prevention order?
Oh, sure. Yeah, thank you. I think that the courts are pretty aware of it. You know, I think even the order that I showed you all earlier shows that, you know, that particular small claims court was very aware of the notice and had an order pre-prepared for that type of circumstance. But in terms of making the judge aware, they should probably bring a copy of their signed declaration to court, any proof that they've sent it to the landlord as well. And if they, you know, have access to a printer, it might make sense for them to print a copy of the actual CDC order, so that they have something that the judge can reference about the order.
Mm-hmm. How does an eviction change when there's no lease agreement in place? Or what could that look like for a tenant?
Yeah. So normally, when there's no lease agreement in place, a court is going to look at the interval of payments. So, like for example, if it's a an oral month-to-month lease, in most circumstances, that means that the tenant or the landlord has to give at least a 30-day notice of termination. So that would mean that, a landlord might say, I'm renting to you on a month-to-month basis. This is your, for example, if they gave a notice today, they would, and it's a month-to-month lease, that tenant would be able to stay through the end of November. After November, they would become a holdover tenant, and then there's an open argument whether or not that would fall under one of the exceptions to this order, as we kind of walk through. So that that is untested ground, I guess I would say.
Kelly from Fox 59, she commented that it's challenging to track eviction filings in small claims court. Do you all have any idea how many have been filed in Indiana so far? I know in our research, we've been working with some partners to try to figure this out, and it's difficult to get an accurate estimate. But do you have any idea, Chase?
No, and I would just second that. I wish that we did have access to that information. I think it would really help us from understand the true nature of the problem and be able to come up with some discussions around policy. But the reason for that is all evictions are coded as SC cases in small claims court, and every other case in small claims court is also coded as an SC case. And so there's no easy way with the current search tools to filter out evictions. And that is certainly something that should change. We track statistics, for example, with foreclosures separately. That's an MF case in superior courts. We track the volume of expungement cases. That's an EX case. And it helps us understand what's happening, how many people are filing expungements and actually obtaining relief. With foreclosures, how many, are we experiencing an emergency related to foreclosures that lawmakers need to react to? Evictions should be no different. In fact, I would argue it's even, in this circumstance, even more important that we would capture that information, because we know that renters are disproportionately affected in this circumstance because they tend to be the workers in the industries that have been most adversely affected by the pandemic.
Mm-hmm. We have a couple of varying questions on people asking if they can provide education to people or clients about the eviction order, including deciphering some of the information in legal questions. Are people able to do that, or should they be directing individuals to your services and hotlines that you've provided?
There's nothing wrong with people providing information. It's always an issue of, not giving legal advice. So if someone needs advice about whether or not they qualify, or they've got another issue with the landlord, they should certainly call us or one of the other legal aid providers to see if we can help. But I would say that I'm very hopeful that the self-help tool that we're working on right now will guide a person through every step of the process to determine if they qualify, and actually help them submit the declaration to their landlord. So I'm hopeful that'll alleviate that need. The other thing that I would offer is that the National Low Income Housing Coalition has very, very good resources on their website. They have the declaration translated in like 10 different languages, so that people who are, don't speak English as a first language can understand what they're signing. They have a frequently asked questions document that's been prepared for renters. So I would definitely point people to the resources on the National Low Income Housing Coalition website.
The questions are still rolling in, so we have a few more. Is a landlord able to charge a fee to a tenant because the tenant accepted or utilized rental assistance?
I've never seen a lease that had a provision saying that. That would be a contract provision that would allow for the landlord to charge a fee, but I've never seen a lease that had a provision that said they could charge a fee in that circumstance. So I would say in nearly every case, the answer would be no, they couldn't.
And then I know you had discussed this earlier, but what happens if the landlord refuses to accept the declaration? And also, what if a judge refuses to ignore the order?
Yeah, so good questions. In the first circumstance, if the landlord, I'm not sure if they're asking about receipt, like if the landlord's not going to accept it, they're not going to literally let them hand it to them. In that circumstance, they should have a witness, with them if they're going to walk it into a building or something like that. Otherwise, I would tell people to send it every which way they can: certified mail, regular mail, email to the property manager. If they show all of those efforts to a judge, I very much doubt the judge is going to say that they can't prove that the landlord got it. And can you remind me the second half of that question? It has to do with judge. Oh, well, if a judge would accept it or not.
What happens if a judge refuses to accept or acknowledge the CDC moratorium order?
So that is an open question. I will just say that. I mean, judges do have discretion, obviously, to make decisions based on the law. And I've already pointed out, I think in this presentation, that it's very much possible that judges will rule differently in these cases. There's no mention in the order of how a court could be, forced to follow the order, how a judge could potentially face penalties or anything like that. So I would just say it's possible that there are courts that are going to interpret it differently, and that's part of the problem of having a one size fits all kind of solution like this. If it were a state specific moratorium, it would probably be a little bit more tailored to state law and be a little bit more clear.
For the open questions in court, do individuals need to rely on Indiana precedent, or can they look to precedent in other states?
So I would say that, I mean, this is new for everyone, right? It's new for courts. It's new for attorneys. I can imagine that even most attorneys that are much more senior to me, and I've only been practicing for 8 years. I can't imagine that anyone's seen an order coming from the CDC that had nationwide implications. So it's all new. And so I honestly, from a practice perspective, and I'm looking for sources anywhere I can for authority about the order. I've looked at, there's some other state judicial administrations that have offered guidance to their judges about the order, some helpful, some not. I haven't seen a case, I haven't litigated a case or seen one appealed yet. And so there's much to be tested. But the interesting part too is, the order is only effective for another couple of months, basically 2.5 months. And so, come December 31st, it'll be moot. So, our focus is trying to advocate the strongest position for tenants and protect them from eviction. I'm not sure if that answered the question, but I tried.
I think it sounded great. Do tenants have to prove that they've exhausted all possible rental assistance available, or just be able to provide evidence that they pursued it with at least one agency?
I mean, it says best efforts, which is meant to be broad and ambiguous in a way. I think if a tenant can, with a straight face, swear under oath that they tried, they applied, or they went on a website and it was closed, because that's going to be possible. It's very much possible that someone's going to go on these rental assistance websites and it's just going to say, we're not accepting applications at this time. Well, merely the fact that they visited the website is proof that they've made a best effort to try and obtain the assistance. So I think in my opinion, it's a very low bar. And I would, unless they haven't tried anything at all, I think that most people can answer that question as a yes and answer it with a straight face.
So this is a similar one of a court refusing to, but what if the court refuses to accept an eviction case for one of the exceptions? So again, this essentially goes back to your question of what if the judge does not accept the declaration?
If they don't accept the declaration, then I think it's a matter of probably an appeal. Because, you know, again, our small claims courts are directly appealable to the Court of Appeals. The strange part about it is that it could be, you know, that could be moot by the time you even get a decision from an appeals court. But that's your typical remedy if you disagree with a judge's decision, is you file an appeal to the Indiana Court of Appeals.
Okay, that looks like all of the questions that we currently have. Thank you so much, Chase, for that information. Again, a quick reminder, I've gotten some questions. The slide deck and this recording will be available later today on Prosperity Indiana's COVID-19 Hub. We are going to switch gears from Chase. And again, thank you so much. So Prosperity Indiana, we wanted to highlight, in addition to all of the great resources that Chase provided and mentioned, including the National Low-Income Housing Coalition and Indiana Legal Services, we did create a handy federal eviction moratorium flyer that breaks down, you know, the 5 qualifications, what a tenant must do to invoke the order. And so just kind of summarizes it to help for those who want an easy resource to provide. And this is accessible as well on our COVID-19 hub. I've included the link here, but our hub is open to anyone, so you can go in there and look at this resource. And now I would like to introduce Natalie James, the newest member of our team. We are so excited for our coalition builder for Prosperity Indiana. She joined at the end of September, and she has some great information to share on upcoming education and advocacy efforts. So Natalie?
Thank you, Michaela. As Michaela mentioned, my name is Natalie James, and I am the new coalition builder for Prosperity Indiana. I work with a number of PI's coalitions doing advocacy and outreach work, including the Hoosier Housing Needs Coalition, which is creating a webinar series entitled Evicted in Indiana. And then this webinar series will be available in the coming weeks. The first one will be October 26th. And this webinar series is essentially a 3-part series that goes deeper into what eviction looks like in Indiana and ways that Hoosiers can get involved in combating the issue. Again, it was created by the Hoosier Housing Needs Coalition, and more information is available on the Housing for Hoosiers website. And we are grateful to the Indianapolis Foundation for sponsoring this series so that we're able to do this work and help everyone get this information. And in addition to this webinar series, we will also be releasing a reading guide for Matthew Desmond's book entitled Evicted. And the purpose of this reading guide is so that anyone, you know, if you are reading with a friend, or if you have a church group you're reading with, or if your organization would like to read the book Evicted, it is a guided tool for you to read the book. And it includes questions for you to ask in each chapter that you're reading, as well as local data, policy data, and also eviction data for Indiana, so that you have a good picture of what eviction looks like in Indiana. And this reading guide will actually be available on the Housing for Hoosiers website on October 12th. Thank you. And let me know if you have any questions. You can reach me at njames@prosperityindiana.org. Thank you.
Wonderful. Thank you so much, Natalie. And we have her email here on the screen if you have more questions about the webinar series and the upcoming book guide. You can also find this information on Prosperity Indiana's staff page as well to reach out to her. I just wanted to thank everyone so much for attending. Thank you, Chase, especially for all of the great information and for really clarifying what the CDC order and moratorium looks like for Hoosiers. We will, again, have the slides and recording posted to our COVID-19 Hub later today. And this concludes our webinar. We hope you all have a wonderful day. Thank you so much.